I'm Grace Hurley. I'm an attorney at CCK.
And I'm Amy Odom. I'm a partner here at CCK.
Today, we're going to talk a little about a topic that doesn't get mentioned as much as it probably could be, and that is VA benefits for reservists. You can only get service connection for disabilities if the initial injury or illness took place during active duty service. And this often means that reservists' conditions do not qualify for VA benefits.
VA considers reserve service members to be on active duty during ACDUTRA, or active duty for training, but only if they are injured or contracted a disease during that period of ACDUTRA. What is less settled is the extent to which this applies if reservists were traveling to ACDUTRA when they were injured or contracted a disease. There was a case in 2022 where the Court of Appeals for Veterans Claims gave some guidance on this issue. The case is called Watkins versus McDonough, and while it doesn't answer a lot of questions at that time, we just received an update that leads us to believe that it might be more helpful than we had realized.
Before we get to that, let's talk briefly about a different case, United States v. Klein. Klein was brought up a lot in Watkins, even though it was actually a case by the Court of Appeals for the Armed Forces. The court in Klein held that reservists are on active duty as of the day they're supposed to report for duty, even if they haven't actually arrived yet. But that case was only looking at when the Uniform Code of Military Justice took effect, so it wasn't clear at the time if it also applied to determining eligibility for veterans benefits.
Fast forward to 2022 and the case that's on our minds today. In a Court of Appeals for Veterans Claims case called Watkins versus McDonough, a reservist developed a medical condition while traveling in response to ACDUTRA orders. In 2012, the reservist filed a VA claim arguing that she was on active duty at the time because her orders allowed a day for travel. But VA denied her claim and administrative appeal, arguing that she wasn't yet on active duty because she developed her condition in a city that was not on a direct route to her duty station.
This looked a bit like a chance for the CAVC to apply the Klein rule and make it official that a reservist was on active duty when on authorized travel. Nice and simple. Unfortunately, the CAVC declined to do that, saying it lacked the evidence required to reach a decision. For one thing, VA had implied it had ordered the reservist to take a direct route, but there was no evidence to that on the record. The CAVC did set aside the board's denial, but instead of making a rule about when active duty status started, they remanded the case back to VA with orders to consider the reservists' arguments.
That brings us to the present day. We just learned that VA has decided to give that veteran nearly $600,000 in retroactive benefits. So it seems like VA did reconsider their original argument that the reservists had to take direct routes during authorized travel in order to be considered on active duty.
And this case is a great example of how crucial the courts are to getting justice for veterans. Before the Court of Appeals for Veterans Claims was created, this case would have ended when VA reached what appears to be a pretty arbitrary conclusion. But the CAVC called them on it, and VA appears to have settled on some more consistent rules.
Well, okay, that's a very quick look at Watkins versus McDonough. If you're a reservist who is denied a VA claim due to an illness or injury during travel to ACDUTRA, you might want to look into a new claim on appeal. Don't forget to like and subscribe for more veterans law updates in the days ahead, and take care.